The first time I saw my parents sitting in that courtroom, they looked strangely calm. My father had his hands folded on the table the way he always did in church, his posture straight, his expression composed, as if he were attending a routine appointment instead of a federal bail hearing. My mother sat beside him, whispering quietly to my sister Rachel, who leaned toward her lawyer with a faint smile that didn't belong in a room like that. The judge was reviewing a stack of documents connected to a bail request for Rachel's husband, Ethan Caldwell, who had been arrested 2 days earlier on federal charges tied to a cryptocurrency investment scheme. From the back row of the courtroom, I watched as the defense attorney calmly explained that the family had secured valuable property to guarantee Ethan's release. According to the paperwork they had submitted, they were offering a piece of land as collateral for the $350,000 bail. It wasn't just any land. It was the 8.7 acres of wetland property outside Portland that I had purchased 7 years earlier and paid off completely in cash. My parents sat there believing the forged signature on a power of attorney would pass unnoticed. They believed the paperwork was perfect. They believed the land now belonged to their solution. And they believed I would never show up. But as the judge lifted the document and began reviewing the property description, Parcel 712-C, I quietly stood up from the back row. 12 hours earlier, none of them had any idea I even knew what they had done. 12 hours before that moment, I had been sitting alone at my kitchen table in a small house on the edge of Portland, Oregon. The evening had been calm and ordinary. I was reviewing notes from a wetlands preservation proposal when a notification appeared in my email inbox at exactly 8:22 p.m. The subject line looked routine enough. Recorded document notification, Parcel 712-C. The message had come from the county's title fraud alert system, a monitoring service I had signed up for years earlier when I first bought the land. At the time, it seemed like a minor precaution. Property records could change without the owner realizing it, and the county offered automated alerts whenever a document was recorded under a specific parcel number. I had almost forgotten the system existed. At first, I assumed the message was related to a zoning review or environmental filing. The land sat along a protected wetland corridor outside Portland city limits, and over the years, a few environmental notices had passed through the county records. But when I opened the email and read the description of the document that had just been filed, something immediately felt wrong. The alert stated that a mortgage instrument had been recorded against the property earlier that evening. That made no sense. The land had been paid off completely 7 years earlier when I purchased it through a municipal auction. The previous owner had defaulted on property taxes, and the city sold the parcel to recover the debt. Most developers ignored the land because of the environmental restrictions surrounding the wetlands. But to me, those restrictions were exactly the reason it mattered. I bought it outright with cash and held the title under my name alone. There had never been a mortgage attached to it, never been a lien, and certainly never been any reason for a new financial filing. Yet the county system was telling me someone had just used my land as collateral. I clicked the link inside the alert and logged into the public property records portal maintained by the county recorder's office. The system allowed anyone to view newly recorded documents once they were submitted electronically. When the page loaded, the filing number tied to my parcel appeared immediately. Beneath it was a description of the document type, property mortgage for bail guarantee. My stomach tightened when I read the name listed under the criminal case connected to the filing. Ethan Caldwell, my sister Rachel's husband. 2 days earlier, his arrest had briefly appeared in the local news. Federal investigators accused him of running a cryptocurrency investment operation that quietly collected millions of dollars from investors across several states. According to the report, the company collapsed when several early investors demanded withdrawals the business could not cover. Prosecutors described the operation as a financial fraud scheme disguised as an investment platform. The bail request listed in the court file was set at $350,000. To secure release under those conditions, the court required collateral worth at least twice that amount. My land was valued at roughly $1.8 million. I scrolled down through the document summary again, hoping I had misunderstood something, but the details were very clear. The mortgage document pledging parcel 712-C as collateral had been submitted by two people listed as authorized representatives for the property owner: Denise Cross, Robert Cross, my parents. For a moment, I simply stared at the screen. It took several seconds for the realization to settle into place. My parents had just offered my land to secure bail for my sister's husband, and they had done it using paperwork that claimed they had the authority to act on my behalf. I opened the attached document preview and slowly zoomed in on the signature block at the bottom of the page. My name was written there: Natalie Cross. At first glance, the signature looked convincing. The curve of the letters and the narrow loop in the last stroke matched the way I normally signed official documents. But the longer I studied it, the more something felt wrong. The ink pattern looked too perfect, almost like a scanned image rather than a fresh signature. Then I recognized exactly what I was looking at. It wasn't a new signature. It was a copied one. Someone had taken my signature from an older document and pasted it onto a power of attorney form that authorized my parents to use my land as collateral. Beneath the copied signature sat a digital notary seal claiming the document had been verified earlier that afternoon. My parents had just forged my authorization to rescue my brother-in-law, and the hearing to approve that bail request was scheduled for the next morning at 9:30 a.m. I stayed at the kitchen table for several minutes after discovering the mortgage filing, staring at the glow of my laptop screen while the quiet of the house settled around me. The notification from the county recorder's office was still open in front of me, and the words, "Property mortgage for bail guarantee," sat there as if they belonged to someone else's life. I reopened the filing package and downloaded every document attached to the record. If my parents had pledged my land to guarantee Ethan Caldwell's bail, the court would require detailed paperwork to support it. Whoever submitted the documents clearly intended them to look convincing. The first page was the mortgage instrument itself. It listed the full legal description of parcel 712-C, including the acreage, the wetland boundary markers, and the recording reference from the municipal auction where I bought the land 7 years earlier. Every detail in that description was accurate. The parcel number, the survey lines, the environmental designation attached to the wetland corridor, all of it matched the official records. Whoever assembled the filing had access to the public property database and had copied the details carefully. The second document explained the purpose of the mortgage filing. The land was being offered as collateral for the bail guarantee tied to Ethan Caldwell's federal fraud case. The document listed the required bail amount as $350,000 and explained that the court required collateral with a minimum value of twice that amount before release could be approved. The appraisal attached to the filing estimated the land's market value at approximately $1.8 million. That was more than enough to satisfy the court. I scrolled down through the document package slowly, realizing that someone had spent time organizing the submission. This wasn't a rushed attempt to fool the court. It looked structured and deliberate, as if the person preparing the documents had studied the legal requirements carefully before filing them. The pages included a property valuation summary, a parcel map showing the wetland boundary lines, and a confirmation that the land was free of any existing mortgage or lien. Then I reached the document that mattered most: power of attorney authorization. The file claimed that I had legally granted my parents authority to act on my behalf in financial matters related to the property. According to the document, Denise Cross and Robert Cross were authorized representatives for the landowner and had full legal authority to pledge parcel 712-C as collateral in agreements connected to family obligations. My name appeared at the top of the form as the principal party granting that authority: Natalie Cross. I zoomed in on the signature block again. The same copied signature I had noticed earlier sat beneath the authorization statement, accompanied by a digital notary seal that claimed the document had been verified 3 days earlier. The longer I studied the signature, the more obvious the forgery became. The ink pattern was identical to the signature on the original purchase document I had signed years ago. Even the small curve at the end of the last letter was exactly the same. No one signs their name in exactly the same way twice. This one had been copied. I leaned back in my chair and looked around the quiet kitchen while the realization settled into place. My parents had never had legal authority over that land. They knew that. When I bought it, I made it clear that the property belonged entirely to me and that I intended to protect it from development. Over the years, they had questioned that decision repeatedly. To them, land that wasn't producing profit was wasted potential. To me, the wetlands were worth preserving. But tonight, the land had become something else in their minds, a solution. Rachel Cross, my sister, had always lived a very different life than I had. She worked in marketing, surrounded herself with people who measured success by appearances, and married Ethan Caldwell 5 years earlier when his investment company was expanding rapidly. My parents admired him from the beginning. He spoke confidently about financial markets and digital assets in ways that impressed them. They believed he represented the kind of success they had always hoped to see in the family. When reports started circulating that some of his investment programs were collapsing, my parents dismissed them as exaggerations. Now those rumors had turned into federal charges, and instead of letting the legal system handle the situation, my parents had stepped in to rescue him with the most valuable asset they could find: mine. I returned to the last page of the filing package and found the court scheduling notice attached to the bail request. The hearing was listed clearly near the bottom of the document. Bail review hearing, 9:30 a.m. Location, United States District Courthouse, Portland. I checked the clock on the wall above the kitchen doorway, 8:47 p.m. That meant the hearing was less than 13 hours away. If the judge accepted the mortgage filing as legitimate collateral, Ethan would walk out of custody that same morning. The entire plan depended on the assumption that no one would question the power of attorney document attached to the filing. My parents believed the signature would pass inspection. They believed the authorization looked real enough, and most of all, they believed the owner of the land would never see the filing before the hearing. They had no idea that I was already reading every page of it, and they certainly didn't expect the property owner to be sitting inside that courtroom in the morning. I sat there for a long time after reading the court schedule, the quiet ticking of the clock on the kitchen wall filling the room while the weight of the situation settled slowly into my mind. The hearing for Ethan Caldwell's bail was scheduled for 9:30 the next morning. That gave me less than 13 hours before my parents would stand in front of a federal judge and present paperwork claiming they had legal authority over my land. Most people in my position would have reached for their phone immediately. They would have called their parents, demanded answers, shouted, accused, maybe even threatened legal action. The thought crossed my mind more than once. My phone sat on the table beside my laptop, my mother's contact information still visible near the top of my recent call list. All it would take was a single call to confront them about what I had discovered. But the longer I stared at the screen, the more I realized that calling them would only give them time to fix the story. If I confronted them tonight, they would deny everything. They would blame the lawyer who prepared the document or claim there had been a misunderstanding about the authorization. By morning, they would walk into court with a revised explanation ready to soften the situation. The forged signature might disappear quietly before anyone else saw it. The entire plan they had built depended on the assumption that I would react emotionally. They expected anger and confrontation. They expected me to make noise. What they did not expect was silence, so I closed my phone and left it exactly where it was. Instead of calling them, I opened a folder on my laptop that contained digital copies of the documents from when I purchased the land 7 years earlier. Inside were the auction certificate, the closing paperwork, and the recorded deed issued by the county recorder's office after the sale was finalized. I opened the original deed file and studied the signature section carefully. My signature appeared there exactly the way I remembered writing it at the county office on the day the property officially became mine. That same signature had been copied into the power of attorney document my parents submitted to the court. Seeing the two versions side by side removed any doubt. The one on the authorization form was a digital image taken from this original record. I leaned forward and zoomed in on the notary stamp attached to the forged authorization document again. The certificate claimed the signature had been verified by a licensed notary operating within the state of Oregon. A name was printed beneath the seal, along with a registration number assigned to the notary's license. Those details were meant to reassure anyone reviewing the paperwork that the signature had been properly witnessed and verified. Every licensed notary in the state was listed in a public database maintained by the Secretary of State's office. If the certification was legitimate, the name would appear there instantly. I opened a new browser tab and searched the registry. The results appeared almost immediately. No record found. I searched again, double-checking the spelling of the name printed beneath the seal. The same result appeared a second time. The notary listed on the document did not exist. That meant the forgery extended further than I had first realized. Not only had someone copied my signature from an old document, they had also fabricated a notary certification to make the authorization appear legitimate. That detail changed the situation completely. Forging a signature was already a serious offense. Submitting a document with a false notary certification to a federal court was something far more dangerous. I leaned back in my chair and stared at the quiet room around me, thinking through what would happen if my parents presented that document the next morning. If they stood in court and confirmed that the authorization was real, they would be making that claim under oath. The judge would assume the paperwork had been verified properly before being submitted. If the document turned out to be fraudulent, the consequences would not end with a denied bail request. It would open an entirely different investigation. The strange part was that none of this shocked me as much as it probably should have. My parents had always believed family loyalty meant stepping in without hesitation when someone needed help. When Rachel married Ethan 5 years earlier and his investment business began growing rapidly, my parents treated him like the son they had always wanted. They admired the way he spoke about financial markets and investment opportunities, even though most of the language meant little to them. Whenever doubts about his company appeared online, they brushed them aside and defended him immediately. My own career never impressed them the same way. I spent most of my time studying wetland ecosystems, documenting bird migration patterns, and working with conservation groups to protect natural habitats threatened by development. When I bought the land outside Portland, my parents questioned the decision constantly. They believed property should generate profit, not remain untouched for the sake of wildlife and water systems. That difference in values had always created distance between us. Tonight, it had turned into something much more serious. I closed the browser window and looked again at the hearing notice attached to the filing. The more I thought about it, the clearer my decision became. If I called my parents now, they would attempt to fix the situation quietly. The document might be withdrawn, excuses would be made, and the truth would disappear before anyone else ever saw it. But if I stayed silent and allowed them to walk into that courtroom believing their plan had worked, the truth would appear in front of a judge, and judges had a way of noticing things families preferred to hide. That was the moment I decided what I was going to do. I was not going to warn them. I was not going to argue. I was simply going to bring the one thing they had not planned for: the original deed to the land. Unlike the digital copies on my laptop, the actual deed was stored in a secure deposit box at the bank where I kept my important records. It was printed on county security paper with a watermark embedded in the fibers and an embossed seal pressed into the lower corner during recording. Those physical details could not be reproduced with a scanned image. If the judge saw the original document beside the forged authorization, the difference would be obvious. I glanced at the clock on the wall again. 9:05 p.m. The bank would open at 8 the next morning. The hearing began at 9:30. That gave me just enough time. I woke before the alarm had a chance to ring, the pale gray light of early morning already filtering through the blinds in my bedroom. For a few seconds I lay still, staring at the ceiling while the events of the night before returned to my mind with perfect clarity. The forged signature, the fake notary seal, the bail hearing scheduled for 9:30 a.m. Nothing about the situation had changed overnight, but something inside me had settled into a calm focus. The uncertainty I felt the evening before had disappeared. I knew exactly what needed to happen. By 7:10 a.m., I was already driving through downtown Portland. The streets were still waking up, the early morning traffic moving slowly through the intersections while coffee shops opened their doors and office workers hurried along the sidewalks. A thin layer of fog hung above the Willamette River, drifting across parts of the city like a quiet curtain that had not fully lifted yet. Somewhere across town, my parents and my sister were probably preparing for the same morning with a completely different sense of confidence. They believed the paperwork they had submitted to the court would guarantee Ethan Caldwell's release before noon. They believed the problem had already been solved. The bank opened its doors at exactly 8 o'clock. I walked inside a few minutes later and approached the counter where a familiar employee greeted me with a polite nod. I had visited the branch several times over the years whenever I needed access to the safe deposit box that held my important documents. After signing the access form, the employee led me through a quiet hallway toward the vault room at the back of the building. Inside the vault, rows of metal boxes covered the walls from floor to ceiling. My box sat near the middle of one column, small and unremarkable, the kind of place where documents could remain untouched for years at a time. The employee unlocked the compartment and placed the box on a table before stepping back to give me privacy. I opened the lid slowly and lifted out the folder labeled Land Purchase Records. The original deed was exactly where I had left it. The document was printed on thick county security paper, slightly textured, with a faint watermark embedded in the fibers that became visible when the page tilted toward the overhead light. In the lower corner sat the raised county seal pressed into the paper during the official recording process. I ran my fingers gently across the embossed seal, feeling the small ridge where the metal stamp had pressed into the page years earlier. No scanned document could reproduce that detail. For a moment, I remembered the day I first received the deed from the county recorder's office. The clerk had handed it to me across a wooden counter after confirming the final recording of the purchase. I had walked out of that building holding the document with the quiet satisfaction that comes from finishing something difficult. Buying the land had taken months of research and preparation. Most investors ignored properties like that because the environmental protections attached to the wetlands prevented large-scale development. But that restriction was exactly the reason I wanted it. The land protected part of a migratory bird corridor that had survived decades of expansion around the city. Now that same document was about to become something else entirely. Evidence. I placed the deed back inside the folder and returned the deposit box to the bank employee waiting outside the vault room. When I stepped back out onto the sidewalk a few minutes later, the fog had already begun to lift from the streets. Sunlight reflected off the glass windows of the surrounding buildings as the city fully woke up for the day. I checked the time on my phone, 8:41 a.m. The federal courthouse was less than 10 minutes away. During the drive across downtown, I tried to imagine what my parents were thinking at that exact moment. They had probably spent the previous evening speaking with Rachel and Ethan's defense attorney, reviewing the documents and preparing for the hearing. From their perspective, they were arriving at the courthouse with a solution that would impress the judge. They believed they had secured collateral strong enough to guarantee Ethan's release. Judges often accepted real estate as bail collateral when the value exceeded the required amount. Everything about their plan depended on one assumption, that the authorization document would never be questioned. When I arrived at the courthouse, a small line had already formed near the security entrance. I passed through the metal detector, signed the visitor log, and followed the hallway signs leading toward the federal criminal courtroom where Ethan Caldwell's hearing was scheduled. The building carried the quiet seriousness common to courtrooms everywhere. Conversations were low, footsteps echoed across the polished floors, and every movement felt deliberate. The courtroom doors were already open when I arrived. Inside, several rows of wooden benches faced the judge's bench at the front of the room. Attorneys were organizing folders and legal files, while a few spectators sat quietly near the back wall. I stepped inside and took a seat in the last row where I could see the entire room without drawing attention. A few minutes later, my parents walked in. My father entered first, moving with the calm confidence he always carried into formal situations. My mother followed beside him, adjusting her coat as she scanned the room briefly before taking a seat at the counsel table near the front. My sister Rachel appeared shortly afterward with Ethan's attorney. She looked anxious but hopeful, the way someone does when they believe a problem is about to be solved. None of them looked toward the back row. None of them realized I was already there. At 9:27 a.m., the courtroom doors closed and the clerk announced that the hearing would begin shortly. The judge entered moments later and took his seat behind the bench. A stack of documents waited in front of him, including the mortgage filing my parents had submitted the night before. I watched quietly as he began turning through the pages. When he reached the property description, he paused. Parcel 712-C, my land. At the counsel table, my father leaned forward slightly while the defense attorney prepared to explain the collateral arrangement. Everything in the room moved forward exactly the way my parents expected it would. They believed the paperwork was flawless. They believed the authorization looked legitimate, and they believed the owner of the land would never appear. From the back row, I held the folder containing the original deed and waited for the moment when the judge would ask the one question that would change everything. The courtroom settled into a deep quiet as the clerk called the case number connected to Ethan Caldwell's bail hearing. Chairs shifted slightly, papers rustled, and then the room fell completely still while the judge reviewed the documents placed before him. From the back row, I watched my parents sitting at the counsel table with the defense attorney, their posture calm and confident. My father sat upright with his hands folded neatly together, while my mother leaned slightly toward my sister Rachel, whispering something that made Rachel nod with a hopeful expression. They looked relieved, almost satisfied, as if the hardest part of the situation had already been solved. The defense attorney stood and addressed the bench. "Your Honor, we are requesting release under a secured bail guarantee of $350,000 while Mr. Caldwell awaits further proceedings." The judge nodded slightly and glanced down at the paperwork. "And what collateral is being offered to secure this guarantee?" The attorney stepped aside and gestured toward my parents. "My clients have provided real estate collateral that exceeds the required amount. Parcel 712-C located outside Portland city limits. The property is owned by the family and carries an estimated value of approximately $1.8 million. The judge turned a page and studied the property description briefly. "That amount is significantly higher than the minimum requirement for this bail." "Yes, Your Honor," the attorney replied. "The family wishes to demonstrate good faith and ensure the court that Mr. Caldwell will comply with all conditions of release." My father stood slowly beside the attorney and faced the bench. "Our daughter granted us authority to manage that property on her behalf," he said calmly. "We are offering it today so our son-in-law can return home while the case proceeds." The judge lifted the document that contained the authorization form. "You are referring to this power of attorney document?" "Yes, Your Honor." From my seat in the back row, I could see the page clearly in the judge's hand. It was the same document I had examined the night before. The copied version of my signature sat neatly beneath the authorization text, accompanied by the digital notary seal that claimed the document had been verified several days earlier. The judge looked down at the page again. "This authorization states that the property owner has granted you full authority to pledge parcel 712-C as collateral in financial matters." "That is correct," my father replied without hesitation. "And the property owner is your daughter?" "Yes. And she has authorized you to act on her behalf?" My father nodded. "Yes, Your Honor." The words hung in the courtroom for several seconds. My mother remained perfectly still beside him, her hands clasped together as though everything unfolding before the judge felt completely routine. Rachel leaned forward slightly in her chair, her attention fixed on the bench while she waited for the approval that would allow Ethan to walk out of custody later that morning. To them, this was simply the final step in their plan. The judge flipped through several additional pages in the filing and paused when he reached the official property description attached to the mortgage document. "The land is described here as 8.7 acres of undeveloped wetland property," he said. "That's correct, Your Honor," the attorney confirmed. "And the records show that the land is owned free and clear with no outstanding mortgage?" "Yes." The judge leaned back slightly in his chair, studying the paperwork once more. For a moment, it looked like the decision might come quickly. Judges often accepted real estate collateral if the value clearly exceeded the bail requirement. Everything in the filing appeared organized and complete, exactly as my parents had hoped. Rachel shifted in her seat and whispered something to the defense attorney, who nodded reassuringly. My father remained standing while the judge reviewed the authorization form one more time. If the authorization is legitimate, the judge said slowly, the collateral appears sufficient to satisfy the bail conditions. My parents visibly relaxed. The judge raised the authorization document slightly. I only need confirmation that the property owner is aware of this arrangement and agrees to the use of the land as collateral. My father answered immediately. She is aware, Your Honor. The statement echoed through the quiet courtroom with absolute certainty. In that moment, the decision became unavoidable. I stood up from the bench in the last row. At first, the movement barely registered in the room. A few heads turned casually, assuming a spectator was simply leaving the hearing. But instead of walking toward the exit, I stepped into the center aisle and began moving slowly toward the front of the courtroom. My sister noticed me first. Her expression changed instantly, confusion spreading across her face as she realized who was walking toward the bench. My mother followed her gaze a second later, and the calm composure she carried into the courtroom disappeared in a single breath. My father turned last. By the time he saw me, I was already halfway down the aisle. The folder containing the original deed rested in my hands, the one document they never expected to see that morning, the original proof that parcel 712-C did not belong to them to offer at all. I stepped into the center aisle and walked toward the front of the courtroom while every pair of eyes slowly turned in my direction. The sound of my footsteps against the polished floor echoed in the quiet room, breaking the steady rhythm of the hearing that had been moving exactly the way my parents expected. The defense attorney paused mid-sentence and looked over his shoulder. My sister Rachel's face had already gone pale, and my mother stared at me as if she could not quite believe what she was seeing. By the time I reached the open space in front of the benches, even the judge had lifted his gaze from the paperwork to follow the movement. I stopped several feet from the bench and raised my hand slightly. Your Honor, I said calmly, may I speak for a moment? The judge studied me carefully. Courtroom proceedings were rarely interrupted by someone walking up from the audience, but something about the situation clearly caught his attention. After a brief pause, he nodded. Please identify yourself for the record. My name is Natalie Cross, I said. I am the legal owner of parcel 712-C. The words changed the entire atmosphere of the room. At the counsel table, my father's posture stiffened instantly. My mother's eyes widened as the realization spread across her face. Rachel turned fully in her chair, staring at me with disbelief. The defense attorney slowly stood up, glancing between me and the judge as if trying to understand what had just happened. The judge looked down at the document still resting in his hand. You are the owner of the property listed in this bail collateral filing? Yes, Your Honor. And you are stating that under oath? Yes. The defense attorney stepped forward quickly. Your Honor, the authorization document clearly indicates that the family has been granted power of attorney to manage the property. I kept my eyes on the judge. That document is fraudulent, I said quietly. The room fell completely silent. The judge lowered the authorization form onto the bench and leaned slightly forward. You are claiming the power of attorney submitted to the court is not legitimate? That is correct, Your Honor, I replied. I never signed that document and I never granted anyone permission to use my property as collateral. My father tried to speak from the counsel table, but the judge raised his hand before he could finish. One moment, the judge said firmly. He turned his attention back to me. If what you are saying is accurate, do you have any documentation supporting your claim? I lifted the folder I had carried from the bank that morning. Yes, Your Honor. I stepped closer to the clerk's desk and carefully removed the document from the folder. Even before handing it over, the difference between what I held and the printed copies sitting on the judge's bench was already visible. The paper was thicker and slightly textured, the kind of security paper used by county record offices for official documents. This is the original deed for parcel 712-C, I said, issued by the county recorder's office when the property was officially recorded under my name. The clerk accepted the document and passed it up to the judge. The judge adjusted his glasses and held the paper beneath the light above the bench. For several seconds he said nothing, examining the page carefully. I watched his fingers move slowly across the lower corner of the document, where the raised county seal had been pressed into the paper. That appears to be an embossed recorder's seal, he said quietly. Yes, Your Honor. The judge tilted the document slightly toward the light again, revealing the faint watermark embedded in the fibers of the paper. That detail alone separated the original deed from the printed copies attached to the bail filing. He then placed the deed beside the power of attorney document submitted by my parents. Side by side, the difference was unmistakable. The signature on the original deed carried the natural pressure marks of pen ink pressed into paper. The signature on the authorization form looked flat and perfectly smooth, like an image placed on the page rather than written there. The defense attorney shifted uncomfortably. Your Honor, he said cautiously, our office relied on the documentation provided by the family. The judge did not respond immediately. Instead, he studied the two signatures carefully for several seconds. Finally, he looked up at me. Ms. Cross, for the record, are you stating that you did not sign the authorization document submitted to this court? That is correct, Your Honor. And you did not grant your parents permission to pledge parcel 712-C as collateral for this bail request? No, I did not. The judge placed both documents flat on the bench in front of him and leaned back slightly in his chair. The quiet confidence that had filled the courtroom earlier that morning had completely disappeared. At the counsel table, my parents sat motionless. The hearing they believed would secure Ethan Caldwell's release had just turned into something entirely different. For several long seconds, the judge said nothing. The two documents rested side by side on the bench beneath the courtroom light, the original deed slightly thicker, its watermark faintly visible when the page tilted, the raised county seal catching the light along the edge. The power of attorney form my parents had submitted looked different now that it sat beside the real document. What had seemed convincing on a printed page suddenly looked thin and artificial. The judge lifted the authorization form again and examined the notary section near the bottom. This document states that the signature was verified by a licensed notary 3 days ago, he said slowly. He read the identification number printed beneath the seal. Then he looked toward the clerk seated beside him. Please check the state registry for the notary listed here. The clerk turned toward her computer and began typing into the database system used by the court. The quiet tapping of the keyboard carried across the silent room while everyone waited for the result. At the counsel table, my father sat perfectly still, his hands now resting flat against the table instead of folded together. My mother stared at the papers on the bench, as if hoping the judge might simply move on and ignore what he had just seen. The search took only a few seconds. Your Honor, the clerk said carefully, there is no notary registered under that identification number. A quiet ripple moved through the spectators seated along the back wall. The judge lowered the authorization document slightly and read the name printed beneath the seal once more. So the notary referenced on this certification does not exist, he said. The defense attorney shifted in his chair. Your Honor, our office relied on the documentation provided by the family when the filing was prepared. The judge raised his hand gently, stopping the explanation before it continued. He turned his attention toward the counsel table. Mr. and Mrs. Cross. My father stood slowly. Yes, Your Honor. You have represented to this court that the owner of parcel 712-C granted you authority to pledge that property as collateral for this bail request. That is correct, my father said, though the steady confidence in his voice had begun to fade. The judge gestured toward the two documents in front of him. The property owner has now appeared and provided the original deed confirming her ownership. She has also stated under oath that she did not sign this authorization document and did not grant you permission to use the land. My father hesitated. There must be some misunderstanding, the judge interrupted him. The certification attached to this authorization also contains a notary seal that does not exist in the state registry. The words landed heavily in the quiet room. That means the document presented to the court contains both a forged signature and a fabricated notarization. No one spoke. The judge placed the authorization form back on the bench. In light of this information, the court cannot accept this property as collateral for the bail request. The clerk began writing immediately. The collateral filing is rejected, the judge continued calmly. The request for bail guarantee is denied. Rachel inhaled sharply beside the defense attorney. She leaned toward him and whispered something urgently, but the attorney only shook his head. Without valid collateral, there was nothing left to argue. Mr. Caldwell will remain in federal custody pending further proceedings, the judge said. The sound of the clerk's pen moving across the page filled the silence. Then the judge looked again toward my parents. As for the documents submitted to support this filing, he said, this court will refer the matter to the district attorney's office for further review. My mother's hand moved to the edge of the table. Submitting forged documentation to a federal court is a serious matter, the judge continued, particularly when the document includes a false notary certification and is presented in connection with a criminal proceeding. My father said nothing. The confidence he carried into the courtroom that morning had completely disappeared. The judge lifted the small wooden gavel resting beside his papers. This hearing is concluded. The gavel struck the bench once. The sharp sound echoed through the courtroom and then faded into a silence that felt heavier than the moment before. People slowly began gathering their papers. The defense attorney leaned toward Rachel, explaining the next steps of the case. My parents remained standing beside the table, neither of them moving as they looked at the documents that had just changed everything. For the first time since I walked toward the bench, my father looked directly at me. His expression held something that had not been there earlier that morning. Not anger, not disbelief, recognition. The realization that the person they assumed would remain silent had become the one witness they could not avoid. The courtroom emptied slowly after the judge struck the gavel. Lawyers gathered their folders, the clerk organized the remaining documents on the bench, and the quiet murmur of people leaving filled the room. I stayed where I was for a moment, standing near the aisle while the reality of what had just happened settled into the space around me. The hearing my parents had walked into with such confidence had collapsed in less than 10 minutes. Ethan Caldwell had not been released. The collateral had been rejected, and the documents my parents believed would quietly solve the problem had instead become evidence inside a federal courtroom. Rachel was the first to leave the counsel table. She walked quickly toward the exit beside the defense attorney, her face pale and tight with frustration. She didn't look at me as she passed. My mother stood next, still staring at the two documents that had just been compared in front of the judge. The forged authorization form had already been placed into the court record, while the original deed had been returned to the clerk for documentation. My father remained still for several seconds longer. Finally, he turned and began walking toward the aisle where I stood. For a moment, I thought he might say something, an explanation, an argument, perhaps even an apology. But when he stopped a few feet away from me, the words never came. He simply looked at the folder in my hands, the same folder that contained the deed they had tried to use without my knowledge. "You came prepared," he said quietly. "Yes," I replied. He nodded once, slowly. Then he turned and followed my mother out of the courtroom. The door closed behind them with a soft sound that echoed in the nearly empty room. I collected the folder from the clerk's desk a few minutes later. The original deed had been carefully placed back inside after the judge finished reviewing it. I thanked the clerk, stepped out into the courthouse hallway, and walked toward the exit. Outside, the morning had changed completely. The fog that had covered the city earlier had burned away, leaving a clear blue sky above the courthouse steps. People moved along the sidewalks, traffic passed through the nearby intersections, and the ordinary rhythm of the city continued without noticing the small legal battle that had just taken place inside the building. I paused at the top of the courthouse steps and looked down at the folder again. parcel 712-C, 8.7 acres of protected wetlands outside Portland. 7 years earlier, I had bought that land during a quiet municipal auction because I believed it deserved to remain untouched. Developers had ignored it because the environmental protections limited what could be built there. To most investors, it looked like wasted potential, but to me, it represented something simple, a line that could not be crossed. That morning, the land had become something more than just property. It had become proof that boundaries matter, even when the people testing those boundaries share your last name. My parents had believed family loyalty meant access to everything I owned. The court had made it clear that loyalty does not override the law. Ethan would remain in custody while his fraud case continued through the federal system. What happened next for my parents would be decided by investigators and attorneys who reviewed the documents they submitted to the court. That part was no longer my responsibility. My responsibility had always been the land. I walked down the courthouse steps and placed the folder carefully inside my bag before heading toward the parking lot. In a few weeks, I would visit the wetlands again, the same quiet stretch of marsh grass and open water where migrating birds stopped every spring. The land would still be there, untouched by everything that had happened in the courtroom that morning. And sometimes that's the quietest form of justice. If you've ever watched someone assume they could use your hard work, your property, or your trust as if it belonged to them, you probably understand why this moment mattered. Boundaries are not loud. They don't require shouting or revenge. Sometimes they are simply a document placed in front of a judge at the right moment. If this story made you think about your own experiences with family, loyalty, or protecting what you've built, I'd really like to hear your thoughts. What would you have done in that courtroom? Leave a comment and share your perspective. And if you enjoy real stories about resilience, boundaries, and moments when the truth quietly turns the tables, consider subscribing to the channel and staying for the next story. This narrative is dramatized for storytelling impact.